Hey, everybody. Quick word here before we go on to the podcast. So, my colleague John Wrench went down to New Orleans to the American Association of Law Schools annual conference, which was earlier in January 2026. And also, a part of that is the Federalist Society's annual faculty conference. And instead of having a big old short circuit live, what he did was spoke to a few scholars about their work that they were presenting at the conference that would be of interest to our fans of IJ. So I think you'll really enjoy these conversations. He spoke to Jonathan Green and Ryan Snyder, who are two young scholars, one of ASU and one of University of Missouri. And then before that, to Kenneth Rosen of Alabama. Think you'll really enjoy the conversations. I just want to give a heads up that John literally spoke to them in the hallway of the hotel to get their thoughts about their articles. And so there's a little bit of noise in the background at times of people going by, perhaps some professors and their young children trying to make a family trip of it in New Orleans, if that's possible. So just be warned. But I think it'll be just fine for you, and you'll really enjoy the conversations between John and these scholars. So, on with the podcast.
Hello, and welcome to a special episode of the Short Circuit Podcast, which we're recording on January 7th, 2026 in New Orleans, in the penumbra of both the Association of American Law Schools annual meeting and the Federalist Society's annual faculty conference. I have with me a very special guest, Professor Kenneth Rosen. Professor Rosen is a professor of law at the University of Alabama School of Law, and he has a very impressive background that includes an LLM from the London School of Economics, a JD from Yale Law School. He worked for the SEC's Division of Market Regulation as a special counsel. He is a member of the American Law Institute and was appointed to represent Alabama on the Uniform Law Commission. Just a few of many notable accomplishments. Professor Rosen, thank you for being on the podcast.
Well, thank you for having me. I'm really excited to get to speak to you, and particularly about a topic I really am pretty passionate.
Yeah, so I'm very excited too. You have a work in progress that you'll be presenting at this conference, and its title is Celebrating the Declaration of Independence, the Underappreciated Importance of Economic Freedom for the Founders and Its Lessons for Today, which is an awesome title, and it's very exciting. Could you just tell me a bit about the project and kind of how it came about in the first place?
Sure. So as a law professor, obviously the beginning of the legal framework of our country and the Declaration of Independence is something that we should reflect on really all the time, but I think maybe more notably on a big anniversary like the one that's coming up. But I am a business, finance, regulatory scholar, so I was really interested in talking about what that means to me and how it intersects with my work. And I came up with this idea that a lot of the times when we think of the founders, we think of them as almost superhuman figures who really are noteworthy kind of politically, but we pay a lot less attention to the nuance of their motivations, and I think particularly to what interests me, the economic freedom motivation that they had. And part of the project starts out by thinking about who were these folks. And when you look at them, they were, from my perspective, a bunch of small business people. And I think a lot of the reason that they decide to revolt, a lot of the law that would come in the early American period was because of that. So I want to look a little bit more into that first, then to see how those ideas got incorporated into early American law, and finally, on the back end, to discuss what they can teach us today particularly as we kind of see a rise of certain movements like the Democratic Socialists in the U.S. today.
Yeah, there's so much there to jump on. So just to start, I think a lot of our listeners will be familiar with the concept of economic freedom and economic liberty. But for people who might not really know what that means or kind of the constellation of ideas that are there, could you kind of give me an idea of what that is?
Sure. So in the colonial period, I think one of the things that was going on for a long time, and maybe why the colonists thought economic freedom was so important, was a bit of benign negligence, if you will, by the British. But then all of a sudden, the British started to come in with a lot of what I would characterize kind of maybe in a more colloquial way, regulation, right? You have the Stamp Act and so forth. And it really, I think, made folks of that period reflect on, we liked when the government left us alone more, because that allowed us to actually engage in the things that would improve our livelihoods, our families, our communities. And, there were reasons, I think, that others have talked about as well as to why the British attitude may have changed a bit. We're talking about the end of the French and Indian War, so they accumulated debt related to that, maybe want to milk the colonies more. They were realizing the colonies was a lot of the source of their wealth, so they were fearful of not having control. But I think the efforts to assert more governmental control, as we all know, backfired. But I think it was a very organic, natural thing for the colonists to want. By the way, I would, contrast the American Revolution to other historic revolutions. Just one of the ways of things being exceptional. So, was there democracy in the past before the revolution? People would argue Athenian democracy, things like that. Were there revolts or uprisings? Absolutely. Peasant revolutions, palace coups, and the like. But what makes the American Revolution, to me, so interesting is people were revolting for a very particular purpose of instituting a replacement governance regime that really focused on them having those kinds of freedoms guaranteed.
Right, not trading it for chaos, but something that actually resolved the problems and built something new. It's very interesting that this connection to kind of the Stamp Act and the British maybe overextending themselves. I was thinking of, often the issues with search and seizure are used as an example of having a significant impact on sparking the revolution. But it is interesting that if you ask why those searches and seizures were happening in the first place, it does all kind of come back to, all roads lead to this, these kind of economic issues that are in the background, both them trying to milk the colonists and the colonists experiencing the search and seizures as a consequence of a government that, to exercise the kind of economic control it wants to exercise, it has to start breaking down doors in a very literal way. When some people, in my experience, when some people hear ideas about economic freedom or economic liberty, I think they often think of something like, in the modern age at least, like deregulating big business, and that's basically where that idea ends. And so I think sometimes they view any talk about economic freedom or economic liberty as the kind of stalking horse to achieve just that kind of regulation. But you were talking about how a lot of people at the founding, it was really like a revolt of small businesses. Could you talk a little bit more about that? These people who were actually, their economic interests were at stake.
Yeah, so, let's kind of think of a couple of the founders, right? On maybe the more famous level. We had folks like John Adams, a lawyer, but I think, at that time, this was not the age of the gigantic law firm. This was a hang your shingle out kind of practice of law. And then more to the south, you had the farmers, who sometimes also were lawyers too, folks like Thomas Jefferson. So it wasn't that there was one type of business enterprise. It was more that these were entrepreneurial folks who were engaged in coming up with business production, if you will, that would be useful in their community, and basically making a living off of it, and again, kind of, helping their families. Maybe I'll channel a little bit of my inner Justice Scalia for the minute. If we look at the text of the Declaration of Independence itself, of course, one of the earliest and most famous lines, and I take them at their word and what they put in the text of the founders, that they want life, liberty, and the pursuit of happiness. I think that was not accidental language. Life, the most basic in many ways of needs, but liberty, I think, as it directly relates to the pursuit of happiness. To me, it was fascinating, right? Again, comparing it to maybe other revolutions, they weren't asking for some particular piece of property per se. What they were saying was, we want to be able to pursue property, wealth, as we see fit, our happiness. And again, you look at maybe some of the lesser known founders, people who were merchants, who started out as apprentices sweeping shop floors. Our natural inclination, once again, is to think of these folks as superhuman, but they were living normal lives, and they want to make their lives better. And I think that was at the heart of the revolution.
Yeah, that kind of link between that ethos at the founding, it seems to have really become concrete, with the Constitution, after the Declaration, with the Constitution, and for at least a good chunk of American history. And I'm wondering, if there has been at times a derailment or a change in those views, or if they've been watered down at all. And if there has been a shift, why do you think that has happened?
Yeah, well, I think there's an ebb and flow, as within all things, that sometimes there are counterpoints being made more vocally, like the socialist movement today in the United States. I don't think it's that we ever lost what the founders were thinking. It's that sometimes we don't make enough effort to talk about what they were thinking and to remind people. So I think if you would talk to an average person, they would still be aligned with that ethos that we're talking about, but maybe they just don't think about as much anymore. That's why the 250th anniversary, I think, is such a valuable thing. It gives us an opportunity to talk more about it. But, part of the reason I'm doing this project is not really to be a one-off, if you will, of let's say something for the anniversary and be done with it, but rather in the back end of the paper to talk about some things we can do in the longer term that will hopefully create kind of more continuous memory, if you will, of why the founders' way was so valuable and why some of the alternatives today that are being presented are quite problematic.
What are some of those things that, kind of turning to the future with this, what are some of those things, those lessons that people should take away from this, and how those could be, operationalized in a way that maybe helps us to remember a bit.
Yeah, so, I think part of it, maybe I'll start a little bit on the negative and move to the positive. When I was a student, as an undergraduate at Cornell and other aspects of my education, we talked about Marxism, communism, socialism, in large part to offer the opportunity for critique and why those ideas were really false promises. If I've done this before, I'll ask a group, raise your hand if you read the Communist Manifesto, and you have blank stares coming back to you as opposed to a lot of hands going up.
Which paradoxically is actually it might seem like a good thing if you don't like those ideas, but it sounds like it's actually a problem.
Yes, and I will kind of joke with the audience. Well, no one wants to admit it because maybe you don't want to be associated with it. But frankly, part of classical education that's being lost not only on this issue but on other ones was putting out a variety of ideas and letting those ideas be tested. And I think, quite frankly, when you test socialism, communism, it's very easy to critique them. But you have to have that dialogue. So oddly, you might think, for a professor who writes about the things I do, one of my concrete suggestions is maybe we should start talking about those things again.
Mm-hmm. Yeah, that's super interesting. I don't think, at least not all constitutional law courses, for example, are going to do a primer on the founding ideas, right? Many students are going to learn doctrine. They're going to learn cases, and even many of those cases, and I think Lochner is a good example of this, are probably going to be passed over mostly, and to the degree that there is commentary on it, it's probably going to be as a dark night of the soul for the U.S. Supreme Court, and not really why was a court majority able to reach this decision, and there's only really one dissenting opinion that says we should do something totally different. Why do you have a court there? It seems like that probably fits in this. It's an example of the treatment of economic freedom in law schools.
Yeah, and I think that, your observation is fair, that we don't talk about the economic freedom aspect in its own right while we're talking about these cases as much as we should. And in a way, it's really a shame because they would provide more context to the opinions. So I'll give you an example of a particular case. So, one of the things I wanted to look at was, how do I prove my point that this was a primary motivator for the founders? Let's look at early American law, both as it is written and as it is interpreted by the early Supreme Court, to see if it is reflecting some of these ideas. So like in the Constitution, I think on economic freedom, if you were asked to people, name something in there that deals with it, maybe the takings clause would come to mind very quickly. But there's so much in there, right? Interstate commerce, the idea that we have to institutionalize the ability for people to not have their opportunity to widely engage in their business in some way be suppressed. The contracts clause is a really interesting one, right? That even though we have had our revolution, we are still going to respect contracts that were around and give them force, which is really critical from an economic perspective, because as I always tell my students, one of the things that businesses need most to help them is predictability. If you do a contract and it may or may not be enforced later on, that's against that. Well, one specific early case, I don't know if you're familiar with, is the Dartmouth College case. And in that one, you had the interesting question, because the Crown had given the college its charter, basically, should it maybe, not have a right to exist in the way that it did after the Revolution? And, the court rejects that idea. But I think Justice Story in particular emphasizes how important it is to the U.S. systemically going forward that we protect these economic contractual rights, and that is kind of why it's in the Constitution, even if people are not necessarily thinking about it all the time.
Yeah, this context that you're kind of painting a picture of, I do wonder why that it seems to have kind of fallen out of fashion. Context is difficult, right? Because you have to be a little bit more interdisciplinary, and it seems like one of the reasons that a lot of this you have been able to articulate it so well is that you think about economics in a way that probably many law professors, unless they're kind of in the law and economics space, they probably don't have that interdisciplinary experience. So it's almost in some ways you have to be maybe calling on people to be a little bit more of a generalist, at least in the areas that are relevant to our Constitution.
Yeah, and that's really a broader issue with legal education, that I've noticed. When I was a student at Yale, but particularly at the London School of Economics, law was viewed as one department of the whole university. Whereas in the U.S., typically I think law is not viewed as a department, but is a separate school. But in being a separate school, perhaps implying that the ideas of the other kind of disciplines are not necessarily relevant or worth kind of pursuing or thinking about. So, maybe it's kind of an accident luck that was the background that I had. It's kind of funny because I am very much a textualist, so I don't, say, use those other disciplines to supplant what the law is. But in terms of understanding what the law is, there is relevance.
Yeah, and I think that's especially true when it's an area like this where there is overwhelming evidence. I think it's fair to say that the founders did have a particular set of views about economic freedom, among many other views. And I think there's a lot of evidence. You can kind of rely on a smorgasbord of evidence there from different disciplines to kind of make those points. But it is, the legal field is so siloed, and I do think law is often taught in a way where you aren't getting this kind of, why is this provision here? What is its context? And if originalism has been useful for anything, at the very least, I think it's kind of turned people towards those maybe first principles and how those first principles should inform, the rest of the Constitution.
Yeah, no, absolutely. I guess the other thing for me too is, I didn't start my career as an academic. I started my career working at a private law firm where I had clients who were affected by the law, working at the SEC where we were in part making the law. And when you do that before you become an academic, I think it gives you more sensitivity to the fact that the law greatly affects people, not only lawyers, and that when you're thinking about the recommendations that you're making, even a scholarly article, let's say, to kind of take heed of that, of what the implications of what you were saying are. And I think trying to be humble and engaging in that process, I always, not only in a piece that is so explicitly historical, but I always try to think about what came before, the history in a very colloquial sense again of it. And while the history is not necessarily binding, again, it's very informative. It makes you, I think, make better choices about what you're going to say.
Yeah. Do you have hope in terms of the current Supreme Court or anything about the political climate or economics, basically any of the things that would be relevant here? Do you think that there's that it's ripe to kind of return to these ideas? Do you think there will be particular obstacles to that in the current moment?
Yeah, well, one thing I think is because of the prominence that's being given to things like the election of socialists and so forth, that maybe it will wake people up a little bit more about the issues and provide a natural vehicle for the dialogue. And I hope, at least when I am engaged in that dialogue, to use as a counterpoint not only my own personal arguments, but the fact that there is a tradition embedded in the American experience that really supports the counter arguments that are out there. One of the things that I discovered in looking at the founders in this period, so again, I've already said what a remarkable type of revolution it was. That begs the question, how on earth did you get so many people from diverse backgrounds, diverse views to cohesively work together to defeat arguably the greatest military in the world? And I think it was the cohesion of a broader shared experience. They weren't, again, all running the same small business, but they were engaging in activities where the same concerns arose. And, frankly, those concerns are not unique to the 1700s. That's what IJ is basically fighting about all the time in the 2000s. So I think that experience, that shared experience, is still there for us to draw on. One of the things, right, that people have so much anxiety about right now is how in our political system, people are so divided, right? And, I hear less people talking about how can we, shrink the gap of divide. Well, maybe one of the ways to do it is to take as an example what was going on during the Revolutionary period, where, again, people have very different views, right? But they were somehow able to see, well, there are certain basic things that unite us and kind of build off of that.
Yeah, that really does bring to the foreground why the Declaration is such a useful opportunity to kind of look back and see life, liberty, and the pursuit of happiness not as these kind of, as you were saying, they weren't there by accident. They're kind of organizing principles. And I really think that that your piece will be timely and a good opportunity for people to use that maybe as a mirror into the past that we can kind of use to bring people closer together and to confront some of those same issues. Thank you so much, Professor Rosen, for sitting and chatting with me about this. We're really looking forward to seeing this go out into the world, and I'm sure we'll hear from you again in the future.
Great. Well, I appreciate the opportunity again. Thank you.
Hello, and welcome to a special episode of the Short Circuit Podcast, which we're recording on January 7th in New Orleans, in the penumbra of both the Association of American Law Schools annual meeting and the Federalist Society's annual faculty conference. I have with me two very special guests, Professor Ryan Snyder and Professor Jonathan Green. Professor Snyder is an associate professor of law at the University of Missouri School of Law. He previously clerked for Chief Justice Roberts on the U.S. Supreme Court, Judge Raymond Kethledge on the Sixth Circuit, and was a fellow at the Stanford Constitutional Law Center. Professor Green is an associate professor at Arizona State University. He clerked for Judge Naomi Rao on the D.C. Circuit. And relevant to what we're hoping to chat about a bit, he received his PhD in history from Cambridge. Professor Snyder and Professor Green, thank you so much for coming on Short Circuit.
Thanks for having us.
Pleasure to be here. So we're planning to chat a bit about Professor Snyder's research paper, which is called Historical Practice at the Founding, and Professor Green's work in progress called Some Traditional Questions About History and Tradition. Before we chat about those specific pieces, I get the sense that they are both in different ways and maybe from different angles reacting to the same kind of backdrop that's going on, especially in like originalist scholarship and some flavors of it that have been developing, and specifically this idea that if originalism is a methodology that looks at the meaning of something of the Constitution as it was at the time it was enacted, does that come into tension with some of the court's more recent practices of looking at things post-enactment, usually words like history, tradition, and practice? And so if that's the kind of backdrop, I was wondering if one of you or both of you could give us just like a catch us up to speed very quickly for our listeners so they can kind of understand what's been going on, over the last few years that's led to that tension.
Yeah, absolutely. I'd be happy to take that. So the court has been interested in history and tradition in its substantive due process cases for quite a while, going all the way back to Glucksberg and even before that to some of the late 19th and early 20th century cases. And the intuition in that line of cases is that a right is impliedly protected against state interference, even if it's not enumerated in the Constitution textually, if that right is deeply rooted in our nation's history and traditions. And what I think is interesting about the court's use of history and tradition more recently is that it's begun using what it calls tradition. In other words, the popularly enacted understandings of the outer limits of constitutionally enumerated rights through custom, through state legislation, through federal legislation, perhaps executive action, as a means of sounding the outer bounds of enumerated rights, like the right to keep and bear arms, like the right to speak freely. This same move has been made in some of the court's confrontation clause jurisprudence. And exactly as you say, John, that's raised questions which Justice Barrett has flagged on the court, and a number of scholars have flagged, about why it's the case, if originalism is a project that's committed to the proposition that the Constitution's legal content is equivalent to the meaning of its terms as popularly understood when they were enacted. Well, why should we care what restrictions on the use of firearms were thought to be permissible in the 1820s or the 1880s or the 1930s? Why should we care what sorts of restrictions on speech were not thought to be constitutionally illicit in the decades or even centuries after the text was ratified? So that's the kind of paradox that I think the court's recent jurisprudence has sort of flagged for a number of scholars in this area.
And just to add a couple of extra points, I agree with all of that. Originalists have long been comfortable with looking at post-ratification practice that takes place shortly after the Constitution is ratified. So contemporaneous practices, even though they happen after the Constitution is ratified, there's a general understanding that those practices can still shed light on what the original meaning of the text was. They're close in time. Those people are likely to understand the language that's being used, the purpose of the provision that's being adopted. The real controversial move has been to look at practice that doesn't come shortly after the Constitution is ratified, but instead comes 50, 100, sometimes 150 years after the Constitution is ratified. what relevance does that have for the original meaning? A lot of this has taken place in the individual rights context, but it's not just limited to individual rights. The court has done the same kind of thing in constitutional structure cases, looking at the recess appointments clause, for example, in NLRB versus Mill Canning. So it's something that the court is doing across the board, and it's not immediately obvious why that is consistent with originalism, which the court professes to believe.
That's super helpful. And could you tell me a bit now about how each of the pieces that you're working on kind of fits into that puzzle? Professor Green, if you want to go first.
Sure. So the work in progress that you mentioned earlier, John, is called Some Traditional Questions About History and Tradition. And it's an attempt to look, to recover, I think, largely neglected tradition of English constitutional thought in the run-up to the Constitution's enactment, and to see whether that might help us square this circle, at least to some degree. And so the basic claim of the paper is relatively straightforward, that constitutional rights in the English tradition were constitutional before they were enacted in text. They were thought to be conditions of the state's formation in the first instance. It's the right to the jury trial, to habeas corpus, to due process of law. These were thought to inhere in the constitutional settlement that was made between the English people and the English crown way back in time immemorial before anyone could remember. So that's the first thing to say. The second thing is that when those rights were codified textually in Magna Carta, in the Bill of Rights of 1689, the codification of those unwritten rights wasn't thought to change their status as a form of customary law, as rights that had been passed down across generations as part of the original constitutional settlement. Those rights were thought to be delimited by custom, by the customary practices of the English state, including the judiciary, and by the customs of the people writ large. And so as the relevant customs that set the bounds of, for instance, the jury trial right evolved and changed over time, well, the limits of what the jury trial did and did not entail, the kinds of cases in which one was or was not entitled to a jury trial, waxed and waned along with that shifting body of custom. It didn't necessarily require parliamentary intervention for the scope of the jury trial right to change. And so that's the basic kind of historical point the piece tries to make. It's just that if it were the case, and to be clear, I don't try to fully flesh this argument out in the paper, but if it were the case, for instance, that rights picked out in the Bill of Rights were identifying a legal object that pre-existed the Bill of Rights adoption, something like the customary ancient constitutional right to keep and bear arms, or to speak freely, to a civil and criminal jury. Well, if that object was thought to be delimited by custom in the decades and centuries before the Constitution's enactment, then it would have been quite natural for an English lawyer in the 18th century to think that changes in customary understanding of those rights going forward would likewise shape the scope of those rights. And so in that respect, it might make sense for an originalist to look at how the right to keep and bear arms, the right to speak freely, were understood in the decades after the Constitution's ratification, because the object that the Constitution codified as fundamental law, these rights, remained customary rights even after they were set down in text.
So that's super interesting. And I'm going to have a few questions after, and Professor Snyder, if you have any questions too, we can kind of go through those. But I thought I'd ask you about your piece as well and get a broad overview, and then I think we can probably jump back and forth between some of those ideas. So could you kind of sketch for our listeners what your piece is about and how it's kind of fitting into this tension we were chatting about?
So my piece is called Historical Practice at the Founding, and it is also an attempt to try to reconcile the Supreme Court's originalist commitments to look for the original meaning of the Constitution with its use of post-enactment practice. The court has given several explanations for why it can use post-ratification practice. The most common one, or one of the most common ones, is this is what the founders did. And interpreters today should interpret the Constitution in the same way that the founders would have interpreted it. And so we should look back to the founding to figure out how they would have interpreted the Constitution. Several scholars have also made similar arguments, and probably the most influential version of this theory is known as constitutional liquidation. And it argues, likewise, that we should interpret the Constitution using historical practice in the way that the founders would have. The problem is nobody has really looked into how the founders actually used historical practice. Both the court and the scholars that I referenced look almost exclusively at James Madison's understanding of how practice should be used. But even if we understand Madison correctly, and I'm not sure that we do at this point, but even if we do, that does not necessarily tell us how the framers as a whole thought about practice. So I approached it from a different angle, and instead I tried to look at what were courts doing around the time of the founding. I start well before the founding with English judicial practice in the 16th, 17th, and 18th centuries, and then look at what early federal courts do from shortly after the Constitution is ratified up until around the Civil War. And what I found is that for approximately 250 years, courts were very consistent with how they used practice. And they used practice as a tool for discovering the original meaning of the law. So it was not a tool to update the law. It was not a tool to allow the law to evolve. It was a way of trying to figure out what the original meaning of the law was. For reasons we can go into, not all practice will actually serve that function. Some practices will be misleading. And so courts also developed a rigorous screening test that they would use to try to separate out practices that were likely to give reliable evidence of the law's original meaning from practices that were unlikely to be reliable in finding original meaning. And that is what the paper does. It tries to look at all of the cases I was able to find that use historical practice and all of the treatises that discuss this topic. So I marched through 75 or so cases, both before and after the founding, and 20 or so treatises that do the same, and try to understand what they were actually using practice to do so that we can compare it to what the modern court is doing.
That's super interesting. So in trying to kind of synthesize the ways in which those works are similar and different, do you think it's fair to say that Professor Green, your paper is making the claim that there are some codifications that kind of brought with them a reference to custom, such that relying on practice post enactment is a feature and not a bug of that approach? And then Professor Snyder, your claim in the paper is something like a way to discipline in like an epistemic way, a way to discipline what evidence courts look at to determine practice and how to weigh it. Any dispute with that synthesis?
Yeah, I mean, obviously our papers are swimming in very similar waters. I have a lot of questions for Ryan, but I guess
you can
answer your question first, though, John. I mean, I think that's right. Look, if the text of the First Amendment read, "Congress shall make no law abridging the freedom of speech, except through such regulations as are consistent with our nation's history and tradition of speech regulations," both as they exist in the 18th century and as they develop moving forward. Well, an originalist, in order to understand the circumstances under which Congress may abridge the freedom of speech, would just need to look to that tradition, because that's where the text would point the interpreter. And a simple way of making the point of that's in my paper is just to say that in context, that's something like what the freedom of speech would have been understood as. It was a right that had been delimited by custom traditionally. It had been codified, yes, but the codification didn't necessarily change the right's character as a customary right. And so debates about, for instance, the original meaning of the words "the freedom of speech" just wouldn't have registered. That wouldn't have been a natural way for an interpreter to attempt to understand the conditions under which Congress could or could not legislate in this area. Because there was an object in the world, a legal object, this pre-existing right, that simply had been codified as fundamental law in the First Amendment. Now, I think, and this maybe goes to the question that I had for Ryan, there are lots of other instances, both in the Constitution and in very old statutes, where either the legislature or the relevant constitutional ratifiers changed the underlying customary law baseline in very deliberate ways. And there, right, when the law is doing something to the world other than simply declaring that what has been in existence to this point will continue to be law, there I think we would be, I think an 18th century jurist would quite naturally want to understand, well, what did the authors of this law understand this change to be? And there it seems to me exactly right that the kinds of evidence of practice it seems to me right that evidence of practice would have a limited probative value, especially as you got further and further away from the enactment of that particular provision. And so I suppose we might be talking about the use of practice in two different contexts. So English judges sometimes distinguish between declaratory and remedial statutes, and it strikes me that a court's posture towards practice might be different in those two contexts in the 18th century. But I'm curious what you think, Ryan.
So, a few things. I do think your discussion of texts that incorporate pre-existing common law rights is a separate category that needs to be discussed separately. I have thoughts, which I'm happy to talk more about. But I do think that is distinct from provisions of law that are entirely new. And so you may see our analysis differ quite a bit if you're looking at an individual rights case that does codify a pre-existing common law right, as opposed to looking at some other provision of the Constitution, a structural provision of the Constitution, that is creating something new, that's not codifying a pre-existing right, but instead is creating a new structure of government. And there, I don't know if we disagree. Professor Green can talk more about whether he disagrees. So I think the area where we're likely to disagree the most is on these codifications of pre-existing rights, which is mostly going to take place in the Bill of Rights. Perhaps not exclusively, but mostly.
Yeah, I had one question about the kind of jump from, you both look at English practice, and I was wondering if, in determining how to treat rights that are in the American Constitution or in the U.S. Constitution, but not even just rights, like really just the Constitution generally. It makes sense that it depends a bit on, is the U.S. Constitution referencing something? But the kind of questions that came to mind there were, I wonder whether the change in system from parliamentary supremacy to the American system and the separation of powers and the enumeration of certain rights, I'm wondering how that might play into things. And I guess my second kind of attached thought is, what about situations where the framers' understanding of the customary right was incorrect, but Like, are we referencing their misunderstanding, or should we be looking to the thing that they meant to be referencing in terms of customs? Do either of you have any thoughts about that?
Yeah, so I'll start with the difference between the English constitutional system and the U.S. constitutional system, and then maybe leave the other question for you. Obviously, you can address both. So I think this matters a lot. English history is certainly relevant. The founders were English. They read English sources. They thought of themselves as English. And so in a lot of ways, looking to English law to understand how the founders would have interpreted the Constitution or statute, I think makes a lot of sense. But I don't think we can just automatically assume that if they did something in England, they would have done it in the United States. Interpretation and the judicial power depends on the underlying system of government that gives courts their power in the first place. So if you set up a judicial system in different ways, it might change the appropriate way of interpreting a statute. So the English constitutional system is very different in this way. The separation of powers in England is not nearly as clear as in the United States. So the Supreme Court of England is the House of Lords, which is also part of Parliament. So you have this blending of legislative and judicial power that leads courts to act in much more of a legislative manner. So there are lots of things that English courts can do, like issue advisory opinions, that are no longer appropriate for the United States. And I think arguably how courts thought about practice is one of those things that might have changed from the two systems. In particular, because of the independence that courts have, which they gained in England, but not until 1701. So for a long time, courts are not independent of the crown. This blending of legislative and judicial power, judges used to write the statutes. And that is going to give them a much different perspective on what those statutes mean and how they should be interpreted. That all changes with the new American Constitution. So I think we have to be really careful. We should look at what English courts did, but we should always ask if those English interpretive practices reflect some aspect of the English constitutional system and whether that aspect of the English constitutional system changed in a way that would make the interpretive practice inappropriate.
I suppose picking up on that, I think I would disagree, maybe not entirely, but it's not clear to me in the late 18th century that the line between English constitutionalism and the new written constitutionalism of the Americans, quote unquote, was quite so sharp as we sometimes presume today. So I've learned a lot from Judd Campbell and Jonathan Guinap, who've written on this. The Supreme Court in Calder versus Bull, which is 1796, I believe, refers to the Constitution of Connecticut, by which it means Connecticut's corporate charter from the 17th century, and the statute law that has been enacted by Connecticut's colonial legislature and its newly independent state legislature. I think constitutionalism as a field of law entails more in the late 18th century than just the words of the constitutional text. Obviously, to the extent that those words conflict with other sources of law, the Constitution takes priority. That's pretty clear from the beginning. But the written Constitution, at least as I see a lot of these debates, was embedded in a deeper and richer tradition of constitutional reflection that involved social contract theory very early on in the American tradition. We get these questions about the relations between the states and the federal government and what kind of sovereignty the federal government is. Have the states delegated some powers to the central government, but ultimately retained sovereignty and some argued a veto right on the federal government's exercise of its delegated powers? Or has there been, in either 1776 or 89, the creation of a separate second sovereign, a national sovereign, and if so, how does that relate to the pre-existing sovereignty of the states? I think, if anything, it's the federal dimension of the American Constitution that really throws up some of the earliest and most difficult problems for understanding the scope of constitutional rights in the late 18th and early 19th century. Simply because there's the English have a unitary system. The common law of England is the common law of the English people. But it's very difficult to start to think about whose customs would do the relevant scope-setting work in cases where, for instance, the Bill of Rights has codified customary laws. Are these laws that cross-reference the customs of the American people writ large? Well, that presupposes that there's something like an American people as opposed to a confederation of 13 different peoples. And I think these questions really are not answered by the English tradition and have to be worked out in the years after ratification.
Are there any, I think you mentioned that you aren't making the claim that there are particular rights in the Bill of Rights, the American Bill of Rights, that fit within the category of customary codified rights, or there are?
Are there rights that were not recognized as rights at common law? Is that the question?
No, that was
constitutional rights.
No, I could have definitely said that more clearly.
No, I just want to answer.
Yeah. So what I'm thinking properly of is there's this category of rights that you're discussing that bring the soil of the custom with them, which could be you need to actually. The assumption is you will interpret this right. In light of its custom, which could be evolving custom as it goes on. And so I'm wondering if are there rights in the U.S. Bill of Rights, the U.S. Constitution, that you think fall into that category, or are you not making that jump?
So in the paper, I don't take a position on which of the enumerated individual rights in the Bill of Rights are or not cross-referencing pre-existing rights, constitutional rights at common law. But I don't think the list would surprise you. I mean, the jury trial right, if there's any right that that was thought to be essential to the English constitutional tradition, the jury trial right has to be one. The right to habeas corpus, the right to keep and bear arms, the ancient rights. I mean, that's what makes a right constitutional in the English tradition, is that no one knows when it began. Conversely, for instance, the Establishment Clause can't have been a cross-reference to a common law right because the English had an established church, as did at least some of the colonies, right? And so I think it would be really quite odd to try to use history and tradition, as in fact the court has done in some of its Establishment Clause cases, to try to understand the outer bounds of that right, because in the language of the 18th century jurists, that's clearly a remedial provision that's added to the Constitution. It's a limitation on the power of the state that simply didn't exist at common law. The English state was and is perfectly free to establish a church in a way that our federal government is not. And so I think carefully going through and understanding the pre-ratification history of a lot of these individual rights is really important for getting straight about the extent to which originalism and traditionalism about rights are not compatible with one another.
Yeah, that makes me think of something that Professor Snyder said about how carefully thinking about the jump from the English system to our system, because I'm thinking of the Fourth Amendment, for example, because someone could make an argument that general warrants were always inconsistent with the custom in England, but there are lots of general warrants, and they exploded in use, and they existed for quite a while. And it's an interesting question about how we should think of that in that context then, right? Because are the framers of the Fourth Amendment bringing the soil of a custom in some senses and excising general warrants and saying, actually, we think that that was inconsistent with the English custom, but we're bringing the rest of the English custom. Do you think that that kind of, that slicing and dicing is probably the more accurate way to do it, or do you think it's more like you bring the right and its entire custom with it?
Well, I think it has to be a case-by-case inquiry. I mean, one of the other complicating dimensions to this question is that, of course, the English state, like any state, could act unlawfully on occasion. And so the existence of a practice, and here I entirely agree with Ryan, the existence of a practice is not proof that that practice has matured into a universally recognized legal custom. The English state did all sorts of unconstitutional things across its history, but the point of asserting that the English state was constitutionally limited was precisely to give critics of the state, of the executive, a legal vantage from which to indict its practice, some of its practices anyway, as unlawful. And this is exactly what we see in a lot of the debates over general warrants in the 1760s and 70s in the American context. I'm not a Fourth Amendment scholar, and I'm hesitant to say a whole lot more about this particular question than that. But I mean, I think what we're looking for is something like a broad settlement as to the limits of the state's authority. And so, I mean, the Fourth Amendment is a great example, I think, of the point I was just making earlier, right? Which is to say, I mean, I think the Fourth Amendment is the right against unreasonable searches and seizures clearly has to be cross-referencing a pre-existing common law, right? But the language of the Constitution itself points us to this question of like, well, okay, fine, but what searches and seizures are reasonable and which aren't? And that's a question that I think in the 18th century would not have simply turned on a judge's intuitions about what is or is not reasonable. There was a well-developed body of customary common law that answered that question, that had evolved considerably across the 17th and 18th centuries. And I don't think it's implausible to think that that body of law was expected to continue developing along those lines going forward. This is effectively the point that Oren Kerr makes in his Katz's Originalism article, which I think is great and makes this point much better than I could possibly hope to hear. So I'd recommend that to your listeners.
Yes. Please. I mean, I was going to ask in terms of this parsing the practices that are illegitimate versus illegitimate. Your paper, you talk about kind of a set of factors or lists, and you were describing this before. I was wondering, were courts describing them as factors, or were they kind of the practices that they were engaging in that you were synthesizing as this kind of set of factors? Like which of those was going on there?
I'm definitely synthesizing what courts are doing. So what you will find when you look at cases that actually rely on historical practice is oftentimes the court will rely on the practice, and it will explain why it's doing that. It will say this practice started shortly after the law was adopted. It's been going on for 200 years. Nobody has ever challenged it. That's good evidence that this practice is actually a good description of what the law means. Other times, you will find courts giving reasons why they're not going to rely on a particular practice. So a court might say, this practice didn't start until 100 years after the law was adopted. We have good reason to think that the people who were engaging in the practice weren't actually thinking about whether it was lawful. So it doesn't really tell us very much about whether it was lawful or not. And if you look at all of those cases, you eventually discover that these same factors are popping up time and time again. And so what my paper tries to do is tries to pull out all of those factors and really isolate the ones that a practice really had to satisfy in order to be considered. So one of them is the practice has to begin shortly after the law is adopted, what I call a contemporaneous beginning. I looked at 75 or so cases. I have not found a single case where a court, either in England or in the United States, relied on a practice that didn't start shortly after the law was adopted. So The court doesn't necessarily always say this is a requirement that every practice must meet. But over the course of all of those cases, I think we can fairly say they required a practice to have a contemporaneous beginning. Otherwise, we would find some where the practice starts much later. So I'm trying to pull all of that together and figure out what really mattered to them and what didn't.
Do you have a sense of if any of those factors weighed more or were more determinative, or do they seem like they were on the plate as considerations and the court kind of picked at them as they were useful?
There's two different groups. So there's one set of factors. There are 7 of them. I could rattle them all off, but that might get a bit tedious. So having a contemporaneous beginning is one, that the law actually reflects someone's understanding of what the law means is another one, that it's long-standing, usually meaning decades, if not centuries. Those all seemed to be requirements that you had to satisfy them all. So you can't really say that one is more important than the other because you have to satisfy every single one of them. There's another, much bigger group of factors that give some extra weight to a practice if they happen to be there, but that don't prevent the court from relying on the practice if they're absent. So one example here, courts were more likely to rely on a practice if that practice harmed the person who was engaging in it. So kind of a question of incentives. If you have a good incentive to not do this thing, but you're doing it anyway, that is extra evidence that that is actually what the law requires.
It's like an admission against interest
Exactly.
or something. Yeah.
Conversely, if the practice benefits you, then they might give it less weight. But that's not the kind of thing that they looked for in every single case. Not every single case is going to involve a practice that either harms or benefits the person who's engaging in it. So they considered it sometimes, and they didn't consider it other times. One other point that's relevant to all of that is that in all of these cases, practice is just one source of evidence that the court is looking at when it's trying to figure out what the original meaning is. So they're also looking at the text. They are also looking at express contemporaneous interpretations, people who at the time say, this is what I think the law means. They're also looking at the purpose. So you have to cross a certain threshold, satisfy a certain number of factors to consider practice at all. But after that, it's a little bit of a multi-factor. Some practices better than others, some get more weight than others.
It sounds more holistic in that sense. So is there I know that you were speaking about liquidation before and some problems or critiques that you have about liquidation. I'm wondering, is there any particular doctrine or area of law that you think, if the court agreed with you on this, would change drastically or more drastically than others?
Yes, several. Probably the best example is the one that I mentioned earlier with recess appointments, NLRB versus Noel Canning. So there, the majority looks at a practice that at the earliest starts in the 1920s. And the court ultimately says, we are going to allow the executive branch to make recess appointments during intra-session recesses. So not the main recess in between congressional sessions, but when Congress goes on shorter recesses, we're going to allow the executive branch to make appointments during those. That, to me, seems inconsistent with how the founders would have thought about historical practice, precisely because that practice does not start shortly after the Constitution's ratification. So that is a situation where I think what the court actually did is going to be different than what they would do if they're actually following the founding era approach. There are others I have found just in the last decade, approximately 15 or 20 Supreme Court cases that rely on what I call late arising practices, so practice that starts long after the Constitution is ratified. That doesn't mean all of those cases would come out differently. Some of them would just rely on different rationales, but certainly some of them would come out differently.
Can I ask a follow-up question on this point, Ryan? Should we think about the court's invocation of historical practice differently in the separation of powers context as opposed to the individual rights context? So oftentimes, Kurt Bradley and Alison LaCroix have written a lot about historical gloss as a kind of negotiated settlement between the political branches that gives our federal system stability over time. So there might be some kind of values to kind of Burkean values to these kinds of settlements that the court's picking up on in Noel Canning and similar cases that don't necessarily go to the original meaning of the words the legislative power or the phrase the recess of Congress, the legislative power, but are rather sort of compromises negotiated over time precisely because the text doesn't give us a whole lot to work with. Should we think about practice differently in that context than in contexts where we have some real kind of constitutional language to sink our teeth into that against which a practice that's arisen later could or could not be tested?
I think that depends on why you think practice matters. So my paper takes as a given that what we are trying to figure out is how the founders understood and used practice. And I take that as an assumption because that's what the court says it cares about. That's what most of the major originalist scholars in this area have said they care about. And so my paper is just trying to say, okay, if that's true, if we care about practice because the founders cared about practice, how did the founders care about practice? So if you take that assumption as a given, I don't think we should think about practice differently in the separation of powers and individual rights context. I don't think there's any founding era evidence that courts treated those two things differently. So I don't think there is reason for us to do so. That said, I am not necessarily personally convinced that we should or have to interpret the Constitution using the same interpretive methods that the founders used. I'm unsure about that. Maybe that's the right answer, maybe it's not. If you don't think that's the right answer, then you can come up with other rationales, Burkean tradition, other reasons why maybe we should treat practice differently. But even in Noel Canning itself, the court's rationale for why it cares about practice is because James Madison cared about practice. And I think if that's your argument, if that's what the court's going to say, then we actually have to figure out, okay, how did James Madison think about practice? How did the rest of the founders think about practice?
Well, I know that we could probably talk about this for hours. Both of your pieces are extremely fascinating. I have a suspicion that plenty of the court's cases over the next few years are going to be opportunities for them to get into this, and hopefully we see some, separate opinions and different justices kind of running down parts of this. And I know that your scholarship will play a role in that. Professor Snyder, Professor Green, thank you so much for being on Short Circuit.
Thanks for having us. This was fun.
Yeah, thank you so much. This was great.